Good afternoon, everyone. Welcome to the City of Madeira Beach Code Enforcement hearing. My name is Bart Valdez, and I'm the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city attorney in just a few moments. In all cases, since the city has the burden of proof, the city will present its case first. The respondent or property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will then be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure that we have your current correct address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role today is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary to swear or affirm that you will tell the truth. Therefore, at this point in time, the city attorney will swear in any witnesses. This also includes anyone from the public that wishes to comment today. So, if you want to speak to me today, please stand, raise your right hand, and the city attorney will swear you in.
Swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? I do. All right. Thank you, everyone.
All right, thank you. Please be seated. The first case on the agenda today is case number 2021.009 involving the property located at 604 Normandy Road. Is the city prepared to proceed?
Yes, we are.
Go ahead, Mr. Trask.
All right, thank you. The city would first call Deputy Snyder. Deputy, you've been sworn in already today. Can you briefly tell the special magistrate what your role and responsibility is here at the city as a deputy?
My name is Corey Snyder. I'm employed with the Pinellas County Sheriff's Office. I've been with the Sheriff's Office almost 7.5 years. My current position is working for the City of Madeira Beach in community policing and code enforcement. I've been here in a code enforcement role almost 3.5 years now.
Thank you. This first case, in fact, the next three cases, is for the property located at what address? 604
Normandy Road, Madeira Beach.
And who's the owner of that property?
The owner of record is a Joe Stepanek.
And how do you know that?
Through the Pinellas County Property Appraisers website and the tax record through the Pinellas County.
Okay. We're going to go through some documents that are marked in the packet that we have today. We're going to start at page 3, and we're going to go through, it looks like page 36, if you have a copy of that.
Yes, I do.
Okay. So on page 3 that we have in the packet here, this is a printout of the property appraiser's records, is that correct?
That is correct.
And it reflects the address of 604 Normandy Road being owned by Joseph M. Stepanek?
That's correct.
Okay. And followed that on page 6, is that also a printout from the tax collector? And does it also provide the same address and same owner?
Yes, it does.
Okay, are you the one that had those printed out from the website?
Yes, I did.
Okay. All right. And this property is being brought to the code enforcement for what type of activity has been occurring on the property that's in violation of city code?
The area is zoned R1 by the city zoning guide, and it's a short-term rental violation, section 110-176.
Okay, and what was your first involvement in this case?
We had been receiving some complaints from nearby residents about the presence of an ad on the Airbnb and the VRBOs indicating that the property was being used for a short-term rental.
Okay, And with regard to short-term rentals in the R1 zoning district, is that a prohibited use?
The prohibited use is less than 6 months.
So the property could be used for rental, it just can't be used for anything shorter period of time than a 6-month period of time?
That is correct.
Okay. So after having received these complaints from property owners or others throughout the city relative to this property, when did you first go out to the property to determine whether there was a violation that existed?
In early of 2000, we began monitoring the property by doing compliance checks, trying to make contact with anybody at the property. We did see the presence of an advertisement on the websites. So in April, I began issuing letters to the property owner, giving him the explanation of the city's rules as far as short-term rental and the requirement that it has to have a rental inspection and business tax.
Okay, and that was April of what year?
April 14th of 2020.
Okay. So going to the documents that we have in the packet, you're referring to specifically page 7 of the documents. It's a letter that you had prepared, correct?
That is correct.
Okay. And in this letter, was it sent to the property owner?
Yes, it was.
And was it sent by regular mail or certified mail or both?
As a practice, all notice of violations get sent both regular and certified mail.
Okay. And in this letter that was sent, did it advise the property owner that there was a violation on the property?
It was explaining that the property could not be used as a rental for any period less than 6 months.
And what code section was that you referred to in the letter?
110-176.
Okay. So the next couple of pages in the packet, 7, 8, 9, and 10, that all relates to that letter that you had sent to the property owner in April of 2020. Is that correct?
That is correct.
All right. Did you talk to the property owner after that letter was issued in April of 2020?
I've talked to the property owners several times over the course of maybe a couple times over 2020. Yes, I have.
Okay. So was the property brought into compliance immediately after the letter was issued in April?
No.
Okay. And did you issue another letter then with regard to this property?
On 6/17 of 2020, I issued a letter again identifying the notice of violation that the property could not be rented for periods less than 6 months.
And that is documents pages 11 and 12?
12.
Is that correct?
That's correct.
All right. And was that sent by regular and certified mail as well?
Yes, it was.
Okay. And page 13 in the packet what does that reflect?
Page 13 shows a listing for the property on VRBO.
Okay, and other than it showing a listing, does it show that it can be listed, it can be rented for periods of time less than 6 months?
Yes, it actually shows a average night is $233 per night.
Okay, so it's being rented per night then, and not in 6-month increments?
It could be.
Okay. And were you the one that printed this off the VRBO website?
Yes, I did.
Okay. What was your next contact with the property owner?
My next contact was in December of 2020. I received information from Mr. Holden Pinkert of the building department that he identified he received a complaint, identified a violation of a 2-week rental period in December.
Okay. Did you go out to the property then?
I did after, actually it was vacation. I returned to the property. The violation was identified per my police report here. On 12/23, Mr. Pinkert made contact with renters, and they identified themselves as 2-week renters. He took a picture, I think, of the vehicle in the driveway, and then provided the information to me. On 12/30, I went to Mr. Stepanik's residence and issued him a non-criminal ordinance violation for the violation of the short-term rental, and cited him into Pinellas County Court.
All right. So the VRBO printout was on page 13, and your police report begins on page 14 and ends on page 17, is that correct?
That is correct.
Okay, and is there also in the packet a photocopy of the citation that was issued to the property owner?
Yes, page 18 shows a copy of the citation I issued.
And does it reflect the code section that's being violated?
Yes, it does.
And is that also 110-176?
Yes, it is.
Did you hand this citation to the property owner?
I did, and he signed my copy, my court copy.
Okay, that's his signature at the bottom of that page on page 18, correct?
That's correct.
Okay. So page 18 and 19 is the citation. Page 20, what document is that?
Page 20 is Pinellas County, Florida Misdemeanor Division, Notice of Municipal Ordinance Arraignment Hearing.
Okay, so that was a hearing that was set for February 25th at 1:30 in 2021. Was the citation paid before that date, though?
The citation, according to the county records, the citation was paid on, it appears to be 1/28/21.
Okay, so was there a plea of guilty then with the payment of the fine?
It says plea rental units R1 zone guilty plea, and it says fine paid.
Okay, and you're referring to the disposition form that's listed at the clerk of the circuit court, page 21 and page 22, what's in the packet today?
That is correct.
All right. Subsequent to December of 2020, was there another violation of the section 110, 176, I believe it was?
Yes, there was.
Okay. And when was that?
On February 13th. Actually, it's a typo here. It should be 2021. And my rental investigation here. Let's see, it was Saturday. I received a complaint from City Hall that there were renters occupying the residence. I had the road deputies make contact with the renters and provide me with the information after their contact.
Okay, so I'm going to be referring to page 23 in the packet. This short-term rental investigation form, is this something that you would fill out in each short-term violation case?
Yes, it would provide me with notes from the investigation of the contact with the renters.
Okay, and so can you go through that investigation, what you found during your investigation of this particular code violation? Deputy
Chasen Connell, at my direction, responded to the property at approximately 4:14 hours, made contact with renters. They said they were from Illinois. They reported to the deputy that they rented it for 1 week from 2/13 until 2/20/21, and they gave him a dollar amount of $2,415 for the time of their stay. They provided their name as Jeff and Christina Olson, and they booked the ad through Airbnb. 1 week, they're from Illinois, and that's the information they provided to me, the deputy provided to me.
Okay, after you received that information, did you issue then a notice of violation for today's hearing?
I did. On 2/17, I issued a notice of violation.
And what were the violation code sections that were referred to on the letter on 2/17?
Short-term rental violation, section 110-176. And at the time also we had the registration 34-503 registration required.
Is the property now in compliance with regard to section 34-503?
Yes, it is.
Okay, and when did it come into compliance?
I believe it was Friday of last week.
Okay. So we're just moving forward today on the code violation of, repeat violation of 110-176, is that correct?
That's correct.
All right. So in the packet, pages 24, 25, and 26, that was the notice of violation letter that was sent to the property owner, correct?
That's correct.
And when it was sent to the property owner, was it sent by regular and certified mail?
Yes, it was.
Okay. Was there a photo taken of the vehicle that was in the driveway the day that it was rented for that 1 week that you had just discussed?
That is correct.
Okay. Is that reflected in page 27 and 28?
Yes, it is.
All right. With regard to the notice of violation, was it posted on the property, or was the notice of hearing posted on the property for today?
It just as just as an extra step, I posted the property with the notice of violation so that all could be aware that the property was posted.
And how did you post it?
I stapled it to a palm tree in the front yard.
Okay, and that was the front yard of the property in question?
Yes, it is.
And that's the photograph that was taken that's shown on page 29 of the packet?
That's correct.
Okay. Did you also issue an affidavit of service reflecting the fact that the notice of hearing for today was sent by regular and certified mail, and it was posted on the property and posted at City Hall?
Yes, I did.
Okay, and that's pages 30 and 31, is that correct?
Correct.
And if you would turn to page 32 in the packet, can you explain what page 32 is and 33?
32 is the statement of violation, which describes the name of the violator, the property address, the parcel number, legal description, and the code which has been violated, which is, again, the R1 violation. And then a sequential, chronological of the action taken against the property, starting from December 23rd when Mr. Holden Pinkert went out to the property and made contact prior to the citation being issued, all the way through the posting of the property.
Okay. And then the affidavit of service, I believe that it's already in there, but we've got it marked as pages 30 through 33. I may have just skipped over that. I'm coming back to it. So the affidavit of service is reflected in pages 30 through 33?
That is correct.
Okay. So the bottom line in this particular case, it was a repeat violation. It was a violation of Section 110-176, and it was in violation from February 13th through February 20th this year. Is that correct?
That is correct.
All right, thank you. I don't have any other questions of you. I'd like to tender into evidence the packet that is reflected as pages 3 through 36.
Thank you, Mr. Trask. Go ahead and accept into evidence as exhibit number 1, pages 3 through 36 of the agenda packet. Is the property owner or someone on behalf of the property owner here? All right. Come on forward, sir. Okay, great. Sure, you can come stand there if you want. Sir, what is your full name?
Joseph M. Stepanek, Michael Stepanek.
All right. Mr. Stepanek, in just a couple minutes, I'm going to give you the opportunity to present anything you want to present to me, to provide testimony, documents. You can even call your realtor as a witness if you want. But right now, this is your opportunity in the hearing to ask any questions of Deputy Snyder based upon what he testified to. So, again, this is just cross-examination or asking him questions. Do you have any questions for Deputy Snyder based upon what he testified to? All right. Stay there for just a second. Deputy Snyder, I just have one question. You said the property was brought into compliance. What was done to bring the property into compliance?
For the business tax, registration business tax?
Okay.
He paid his registration and application for rental inspection program on Friday.
Okay, because I saw that in the documents it said, please remove online or come into compliance. So
Right.
I take it the come into compliance would be to pay the business tax and become part of the rental inspection program?
That is correct.
Okay. All right. Mr. Stepanek, just stay right there. I need to see if the city's going to call any other witnesses.
We have no other witness on this case.
All right. Mr. Stepanek, this is now your part of the hearing where you can tell me anything you want to tell me, or you can call, or you can call witnesses. So whatever you want to do, there's no real formal rules here, but this is your opportunity to give me whatever kind of evidence you want to give me.
Okay. Originally, I was shown the property by Chris, real estate agent. I purchased the property under the pretense and the listing saying specifically no limits to leasing the property. Got a commercial loan as a investment property, and everyone that was involved in the giving me of the loan was under the pretense that I could rent this property with no minimums. I got a $500,000+ loan on it put $100,000 of my own money down. And,
Ms. Trask, are we still recording, or do we need to? These are recorded.
All right, we're good to go.
Mr. Stepanek, with you, I think the last thing you told me was you'd applied for the loan and the representations were always you'd be able to...
invested my retirement, $100,000 into the property as well, under the pretense that I could rent it. And that's where I am right now. Have to pay the mortgage, monthly mortgage on the property, and right now I have it listed to rent for a year. I've had no interest whatsoever. I'm attempting to get someone in there permanently so that I don't have to continue trying to make money to pay this mortgage. And that's basically where I am.
All right.
So I'm making a big attempt to rent it. There is no interest for someone that would want to pay the amount it's going to take for me to cover that mortgage. Although it's not a bad number that I have it listed for to get someone in for a year. That's what I'm trying to do. A year, 6 months, or a year.
Okay.
And that's pretty much where I'm at right now.
All right. Mr. Trask, any questions of the property owner?
Yes, sir, I'm Tom Trask. I'm the city attorney. With regard to this particular case, there are 3 cases against you today. This particular case, you heard the deputy testify as to the fact that this property was rented from February 13th to February 20th. You acknowledge, in fact, that the property was rented for that period of time?
Yes.
Okay. And can you confirm that it was rented to Jeff and Christina Olson during that time period?
I would have to check. I don't.
Okay. Can you confirm that you received $2,415 for the rental for that 7-day period of time?
I would have to check.
Okay. But you wouldn't dispute it at this point that it was at least...
I wouldn't dispute it, no.
Okay. All right.
I'm not disputing renting the property.
Okay. And with regard to the deputy's testimony that he had previously issued you a citation for this code section 110-176, you remember him coming to the house, correct?
Yes.
And you remember signing that citation?
Yes.
And you paid for it and admitted your guilt that there was a violation at that time?
Yes.
Okay. I have no other questions. Thank you, sir.
All right. Mr. Stepanek, you are welcome to call your realtor as a witness if you want and ask him questions. You don't have to, but you're welcome to do that.
Yeah, I would like to call him.
All right, and so you get to ask him questions, so just ask an open-ended question, and he can tell me what he wants to tell me based on your questions.
Okay. Chris, would you like to make a statement?
Yes, I would. Like you said, my name is Chris Grasso. I'm with Berkshire Hathaway out of Clearwater, in Clearwater Beach. I represented Mr. Stepanek in...
I'm sorry, just so I can put it in the order. Spell your name for me again, or spell your name for me.
It's Christopher.
Okay, last name?
Grasso, Grasso.
Okay, thank you, Mr. Grasso. Go ahead.
Yes, I've represented Mr. Stepanek in the purchase of this property, which closed on September 13th of 2019, at which time was represented in the MLS as a no minimum rental. As Mr. Stepanek has stated, it was listed by a couple local agents, a team out of Keller Williams Gulf Beaches, Ethel Bunz and Brian Allen Manley, who actually live and work in this area, in this community. They assured us that this was a no minimum area, and no minimum rental area. And like Mr. Stepanek said, this purchase was predicated on the fact that he would be able to rent this with no minimums. I did some research just today and pulled some properties that you have in these areas right now, currently listed or sold within the past year.
I would object. It's not relevant.
Yeah, I sustain that objection. Move on to your next point, Mr. Grasso.
So it's not relevant that there's confusion in this market as to how these properties are being represented by real estate agents in the area?
Not at all, because this proceeding, as I said in my opening, the only issue before me today is whether this particular property is in violation of the specific code provision that the property owner has been charged with today. So that's the only issue before me today. If the seller made some misrepresentations to the buyer, that's an issue that's not before me today. If there's other confusion in the marketplace, that's not before me today. Because there are different areas of the city where you can have short-term rentals.
Sure.
So, again, that's not an issue, but if there's something about this particular property you want to tell me about, or this particular violation, I'm ready to hear that.
I wouldn't have anything on this particular violation.
All right. Mr. Trask, any cross-examination, Mr.
No, sir.
Grasso? All right.
No, thank you.
Thank you, sir. Mr. Stepanek, anything else you want to tell me, anything else you want to show me in regard to this particular violation?
No, I don't.
All right. You can go ahead and have a seat. All right. At this point in the time, we'll open it up to public comment, and this is specifically about anyone who wants to comment or has knowledge about the particular violation at issue in this first matter on the agenda. Is there any member of the public that wants to come forward and speak? Okay, we'll go ahead and close public comment. Mr. Trask, any closing remarks?
Just briefly, this is a repeat violation under Florida Statute Chapter 162. It's a repeat violation because of the fact that Mr. Stepanek has already been found in violation of this same code section 110-176 previously. He's admitted his guilt. We've provided the documentation that would reflect, besides his admitting that, the documentation with the court system showing the disposition of the case, and it was found to be a violation of that particular code section. This being a repeat violation, it's appropriate to fine the property owner for the days that the case for the property was in violation of the code. Those were the days of February 13th through February 20th of 2021. And we're asking that you find the maximum fine amount of $500 per day for every day that the property remained in violation for those 7 days. The reason being is that anything short of that would provide a windfall to the property owner for having rented it without having to deal with the city code section. So we're asking that you find a violation for those 7 days, February 13th through February 20th, at a dollar amount of $500 per day.
All right, thank you, Mr. Trask. I'm going to go ahead and find that the property was in violation and that the city has proven its case by preponderance of the evidence. And since this is just the first one, I'm only going to impose a fine of $250 per day from the 13th through the 20th. We'll take up your other requests in the other hearings, even though I do realize there was a non-criminal case, but I think this was the first one, at least before me, in this one. So we'll do it at $250 a day for those 7 days. Anything else on case number 2021.009?
No, sir.
Let's move on to case 2021.017. Is the city ready to proceed?
Yes, we are.
Go ahead and call your first witness.
It's going to be the same witness again, Deputy Snyder. We're going to go through the process, and hopefully we can do this just a little bit quicker since we've established a baseline here. So, Deputy, this property went into violation again after this second term, February 13th through February 20th. Is that correct?
That is correct.
Okay. So we're going to go ahead and look at the packet that we have before us and move through that packet quickly so we can get it into evidence. So pages 37, 38, 39, and 40 shows the property appraiser records and the tax collector records reflecting that Mr. Stepanek is the owner of this property?
That's correct.
Okay. And then pages 41 through 56, that's the uniform citation documentation that we had previously discussed?
That is correct.
Okay. In this particular case, how was it brought to your attention that there was another violation of the code of 110-176 on this property?
Knowing that there was activity at the property, we were conducting weekly checks to determine whether any further short-term rental activity was occurring. On 226, I proceeded to the house and made contact with a renter. The renter provided with information that she rented the property for 8 days, from 220 to 228, for $250 a day. She advised me that the property had been, the advertisement was on Airbnb, and she provided her name as Renata Kazmarska, and that was actually captured on body camera, which I have brought today to view if necessary.
Okay, so we're going to see if we can cue that up right now before we move on to the rest of the case. This body camera, this is your body camera that's only activated when you activate it?
That is correct.
All right, and is there some type of 30-second or minute delay or something?
There should be a 30-second lead-in, which is no audio. I believe it might be capture me driving up to the residence or getting out. It should be for the date, show 226 on there, the very top. I can't actually see that far. So.
Yes, that's what it says.
Okay.
And if we could go ahead and play that. And Megan, the audio is on. I can't see you.
It's going to be, first 30 seconds is going to be quiet, muted.
And as we're waiting for the audio to come on, this is you walking towards the front of the house that we're talking about today, which is 604 Normandy Road?
That is correct.
Okay.
Airbnb.
So we are leaving on Sunday.
Sunday. So you came in on, what day is today?
On Saturday we came.
Saturday, last Saturday?
Yeah, last Saturday.
Saturday to Sunday, a couple days.
So it's 8 days altogether.
To this upcoming Sunday. Do you remember how much you paid?
It was like, I think $250 a day.
$250 a day?
A night, yeah.
A night, okay.
Yeah.
Any other fees in there too, like a cleaning fee on top of it?
Yes, there were some fees, cleaning fees.
Okay.
I don't remember how much.
That's fine. Did you guys bring a car or your?
No.
Okay, like Uber and.
Uber.
Okay,
Uber.
very good. Airbnb, 8 nights, Saturday. You're checking out this Sunday.
That's right.
Okay, and then just not your birthday, but just your name.
Renata?
Renata.
I booked it, yes.
And what's your last name?
Kazmarska, K-A-C-Z-M-A-R-S-K-A.
You're not in trouble. It's just
Yeah.
the owner.
I hope the owner is not.
No, it's just, well, see, technically in this section of the neighborhood, that he's not supposed to do weeks. He's supposed to do longer term than weeks.
Oh,
Because
really?
the city has a rule, yeah, and it's nothing on you, and he knows. But, yeah, and what happens is some of the neighbors complain.
All right, Megan, we can go ahead and cut it off.
Called and like the,
We got the information that we needed. So back to the packet of information that you have in front of you on page 57, that short-term rental investigation form, that reflects the information that we just went over through your testimony and what we just heard on your body camera, correct?
that is correct.
Okay. And then subsequent to that, you've issued another notice of violation for the property, correct?
That is correct.
And when did you do that?
2/26.
Did you send that, and that's pages 58 through 60?
That is correct.
Okay. And you cited the property owner again with a violation of 110-176?
He was issued a notice of violation.
Okay. And so, but he was cited with a violation of 110-176 and also 34-503 in that letter?
That is correct.
Okay. And did you subsequently issue an affidavit of service and a notice of hearing for today's hearing?
That is correct.
Okay, so those are the documents all the way through page, it looks like 67, is that correct?
61 through, that's correct.
Okay. So to summarize, in this particular case then, this property was in violation again. It was in violation from February 20th, 21 through February 28th, 21. It was rented for 8 days, and it was rented for $250 a day.
That's correct.
Okay. I have no other questions of the deputy. I would tender into evidence the documents that we referred to, starting at page 37 and ending on page 67.
All right, we'll go ahead and accept into the record as exhibit number 1, pages 37 through 67 of the agenda packet. Mr. Stepanek, just like in the last hearing, if you want to, you can come forward and ask any questions of Deputy Snyder. Okay. All right. Mr. Stepanek, just come forward to the mic just so you can, they can pick up what you say next. Again, this is the opportunity, and soon. Any more witnesses, Mr. Trask?
I may want to call the property owner if he's not, once he's completed.
Okay, no problem.
Okay.
Mr. Stepanek, anything else you want to tell me about this particular violation?
It's exactly the same.
All right. Mr. Trask, do you have any questions for the property owner?
Just a few, sir. So I just want to confirm then, you're not denying that the property was rented from February 20th through, I got to finish my question. February 20th through February 28th, and you rented it for 8 days. And can you confirm that you were renting it at $250 a day?
I cannot.
Okay. Has the rate changed? Is that why you can't confirm that? The rate has changed over the last couple of months?
Changes.
Depending upon who's renting it? Okay. Is that a yes?
Yes.
Okay. All right. I have no other questions. Thank you.
All right. Mr. Stepanek, anything else you want to tell me on this one? Okay. Thank you, sir. I don't have any questions for you. Okay, just like in the last hearing, this is the opportunity for any member of the public who wants to come forward and provide any information in regard to case number 2021.017. Is there anyone from the public that wants to come forward and comment? Okay, seeing none, we will go ahead and close public comment. Mr. Trask, anything else?
So what the city is looking for is that you find a violation of section 110-176, and you find him in violation for those 8 days that he was in violation from February 20th to February 28th, 2021. And again, we're seeking $500 a day for a fine for this violation, this being now the third violation from the same property owner.
All right, based upon the admissions of the property owner as well as the testimony of Deputy Snyder and the evidence reviewed by the body camera footage, I'm going to find that this property is in violation. I'm going to go ahead and find that it is appropriate as a repeat violation to assess a $500 a day fine for the 8 days the property was rented from 2/20/21 to 2/28/21. Anything else on this particular case, Mr. Trask?
No, sir.
All right, that will conclude the hearing in case number 2021.017. Are we ready to move on to the next case?
May I proceed?
Ready?
Okay.
Go ahead.
So this is against the same property owner, the same property. Deputy Snyder, again, we're going to try to move through these quickly.
That's correct.
Okay. So these first pages in the packet, starting at page 68 and going through page 71, that's the property appraiser and tax collector's record reflecting that Mr. Stepanek owns this property, correct?
Yes, that is correct.
Okay. And the pages starting at 72 going through 87 reflect the violations that were occurring from April and through December, and then the uniform citation issued and the disposition by the circuit court.
That's correct.
Okay. So let's jump into page 89 that you have there. And, I'm sorry, 88. This property was brought to your attention again as another violation, and you have your short-term rental investigation on page 88?
That is correct.
Okay. And was this also a case where you had your body cam available?
That is correct.
All right. So if we can go through the basis of it, though, what was the next violation?
The next violation was on 3/5 of 2021. I proceeded to the residence. I identified a 2-week rental period from the tenants. Initially, the tenants told me that they were cousins of the homeowner, and I left the scene. The renter came out to my car, told me he was sorry, he apologized that he had lied to me, and provided me with a true statement that he rented the property for 2 weeks from 3/4 until 3/18 for a total of $7,118.59. He also provided me with his cell phone, at which I took screenshots and emailed them to myself for the case, explaining that if law enforcement or any city official were to show up, that we were just to say that they were a cousin and that we would go away. Let's see here. I determined the property was located on Airbnb. Identified the renter, a Douglas Yost from St. Louis. The time frame, which was less than 6 months, and the dollar amount that was paid for the rental, and this occurred on 3/5, and again back at 604 Normandy in Madeira Beach.
Okay, and we have that body camera today.
Yes.
And we go ahead and turn that on. Megan, is that possible to turn on? Okay. So you're approaching the property again at 604 Normandy Road,
That's correct.
and it was on March 5th, 2021, just before noon hour?
Correct.
Okay.
Sorry to bother you. Hey, how you doing? Deputy Snyder. I work with code enforcement in the city.
Okay.
And I just had to check rental activity at the house.
Okay.
So 604 Normandy. Are you guys renters?
I'm the cousin.
Cousin?
Joseph, yeah.
Okay, you're a cousin. Okay.
Yeah.
He told me that family was coming into town, so. Okay. So didn't pay anything, didn't rent it?
No.
No Airbnb, B&B, that kind of stuff?
Yeah.
How long you staying?
2 weeks.
2 weeks. So when did you guys get here?
Yesterday.
Yes. Today is, so Thursday you got here, and then like Thursday to Thursday or Thursday to Friday, or?
It'll be March 4th to the 18th.
March 4th through the 18th. Okay, and can I get your first and last name, sir?
Douglas.
I'm sorry?
Douglas?
Douglas?
Yes.
And what's your last name?
Jost.
Spell it.
Jost.
Got it. Okay. Card? Did I stop by? The owner knows. Yeah, this is not anything unheard of. Thank you very much.
Bye.
Okay, so after you left the doorway, you're back in your car, and Mr. Jost approaches your car. Is that what happens next?
That's correct.
That's correct. The initial, again, having to manually activate the body camera, there's a 30-second window where it's just video, and then the audio will come up.
So is he talking to you during this?
He is talking to me right now, yeah. We're just missing the audio because of the way the camera activates. That's the indication that the audio is on.
Where'd you guys fly in from?
St. Louis.
St. Louis? What's your weather over there?
Well, it's getting warmer. It was.
I know.
It was.
I think last weekend was pretty warm. I think it's supposed to be like 70s or something like that this weekend, but it's still it's pretty nice. So maybe a little
Here, let
breezy.
me see if I can. Actually, if you want.
Oh,
you wrote it. No, you can read it.
Yeah, I'll read it. Let me just take a picture of it.
Okay.
I'll take a picture of your picture there, and then.
Well, you may have to scroll down as well.
Oh, is there a whole bunch there?
Once I can.
Is that an AirPhone? iPhone?
Yeah. Maybe I can just
copy it. How about just the meat?
Or how about I just
Just the meat of it. You could email it to me. Just the screenshots, you know.
Yeah, I'll just.
It's just a game that these guys play. And honestly, the rules may change on a state level to where right now it's the city's laws that you can, and it's zoned like this is 6 months, and getting closer to Gulf Boulevard where the beaches are, it's 3 months, and then on Gulf Boulevard it's any night. It's a free for all. But out here it's 6 months. So, and I appreciate you telling me, you know, the truth. Because I was just going to send an email saying, as I suspected, you know, I believe he was going to coach the people. And when you came back out, you're like, I'm sorry.
Well, I shouldn't have done that.
Never put you in a position to do that. You know,
well,
that's not fair to you as a renter.
You
know, yeah, and I really appreciate your honesty. No, you know, it's not fair to you. So it's just, and so.
All right, so let me see.
So just to confirm here, it was March 4th through the 18th. Is it pronounced Yost?
Well, it should be, but we say Jost.
Jost, okay, Douglas Jost, St. Louis, Airbnb, and about $300 a night is what you were saying there?
I'll find it here.
Okay.
Right here. So,
2 weeks, though. You'll have a good time here. What are you going to do when you're here?
we were looking to find a place, and then also my wife wants to spend time on the beach.
Oh, yeah. It's great right now. I just drove look at the sand on my wall, my running board there. I was just out there. Tomorrow's going to be busy. So you know, you can have alcohol on our beaches, just no glass.
Oh, we don't plan to drink.
Oh, yeah, it's okay.
Well, actually, it's $385.71 for 14 nights. So,
383.
Here it is, right here.
Yeah.
If you want to take that.
You can just tell me. I'll get it.
Tell you what, I'll just email the receipt.
Popular guy today.
And what is? Oh, you gave me.
So
the card, right?
yeah, I'll give it to you. Like the email, it's C. Snyder, SNYDER, initial C for Corey, Snyder, SNYDER, and it's at PCSOnet.com. PCSOnet.com. That's Pinellas County Sheriff's Office net.com.
C. Snyder at PCSOnet.com.
That's it. Okay. That's it, yeah. So, yeah. Did you ever talk to him directly on the phone?
Yeah.
Oh, you did? Okay, all right, yeah. And again, you guys, there's no fault of your own. It's just something that he's supposed to, you know.
Okay, Megan, we can.
And even though you're here, you know, nobody around here should harass.
Okay, thank you. So Deputy, you've already testified that he, in fact, told you that he was the cousin, came back out to the car, told you that he lied to you, and the reasons why. Did There was a phone that was being provided to you. Did you take the opportunity to take photographs of what was on the phone that he was providing to you?
I did.
Okay. And is that
I
listed?
did.
Thank you. On pages 92 through 95, those were photographs of his phone?
That's correct.
And this is where he confirms that the property owner told him, just to tell you that he is a cousin, and it also goes through the dollar amounts of what he was paying and how long he was going to be there.
That is correct.
Okay. So you issued then, Mr. Stepanek, a notice of violation on March 5th. That was a letter that was on page 89 through 91 in the packet. 89 through 91?
That's correct.
Okay. And then you also issued an affidavit of service and a notice of hearing for today, and those are the rest of the pages all the way through page 102 in the packet, correct?
That's correct.
Okay. All right. I would tender into evidence the last packet of information for this property owner, starting on page 68 and going through 102.
All right, we'll go ahead and accept into evidence as exhibit number 1, pages 68 through 102 of the agenda packet. All right, Mr. Stepanek, just like in the last hearing, this is your opportunity to cross-examine Deputy Snyder. I take it you do not want to examine Deputy Snyder at this point in time? Okay, so let the record reflect that Mr. Stepanek has declined any cross-examination. Mr. Stepanek, come on forward. Mr. Trask may have some questions for you, but again, this is also the opportunity to tell me anything about this particular violation you'd like to tell me.
No, I'd like to say that I'm not embarrassed. I'm trying to make my mortgage.
Okay, I understand. Sir, Mr. Trask?
Just a couple of questions, sir, again. So you can confirm that, in fact, the property was rented from March 4th through March 18th?
Yes.
Okay. And you received $7,118.59 for that rental?
No.
Okay.
Airbnb is involved in the process, too. I'm surprised they're not here.
Okay, so that was what the tenant was charged, though, $7,118.59. You don't know?
I only receive certain amounts.
Okay.
They make a pretty large portion as well.
Okay, they being Airbnb makes a percentage of that or something, a dollar amount, correct?
Yes.
Okay. All right. But you're not disputing the fact that it was rented for a period of time less than 6 months. Okay. All right. That's all I have, sir. Thanks.
Mr. Stepanek, anything else you want to share with me about this violation? All right, thank you, sir. At this point in time, this is the opportunity for any members of the public who want to provide comment about this particular case to come forward and provide comment. Are there any members of the public that want to provide comment today? Seeing none, we'll go ahead and close the public comment portion of today's hearing. Mr. Trask, anything else?
I just wanted to do some of the math for you. I know you probably already did it. But the city is again seeking that you find the property in violation this time from March 4th through March 18th, 2021 at $500 a day for those 14 days. I went ahead and divided the number that was paid, $7,118.59, which is what the tenant paid. That works out to $508.47 a day. Whether or not this property owner receives all of that, we're asking for the maximum amount of fine so that this will stop and so it doesn't happen again. So that's our summary. We're asking you to find the violation for that time period for $500 a day.
All right, based upon the testimony of Deputy Snyder, the body cam footage, and the statements and text messages from Douglas Yost, the admission by the respondent that the property was in violation, I'm going to go ahead and find that the city has met its burden and that the violation did occur from March 4th, 2021 to March 18th, 2021, and agree with the city that there's been a repeat violation here. Therefore, the appropriate fine is $500 a day for those 14 days within which the property was rented. So that is all today in regard to this hearing. Mr. Stepanek, I would encourage you, I can't give you any legal advice here, but I would encourage you to seek a lawyer in regard to any potential claims you would have against the seller of the property. I think you understand what your obligations are with the city right now, and as you can see, if they find that you continue to rent this, they're going to bring you back up here and ask me to do $500 a day every time you rent it on a short-term basis. So just be prepared for that, because we've seen that before in other cases in the past. So the city is serious about enforcing its short-term rental ordinance, okay? All right, that concludes the hearing on case number 2021.020. We ready to move on to the next case?
Yes, sir. Thanks, Gordon. Okay.
All right, we will now hear case number 2020.1258 in regard to the property at 546 John Pass Avenue. Go ahead, Mr. Trask.
I have several witnesses today. I'm going to start out with the documentary evidence first, and then follow up with the building official and also the planning director. So the first person I'd like to call today is going to be Holden Pinkert. He's code enforcement staff here at the city. Holden, you've been sworn in today, correct?
Correct.
Okay. So we're going to go through the packet of materials that has been provided to the special magistrate. Is there someone here on this case today? Okay. Good, thank you. So let's start with the packet of information that we have with us today. Starting at page 103 of the packet, this property that we're here on today, 546 Johns Pass Avenue, is property that is owned by whom?
Jeffrey and Michelle Helms.
And how do you know that?
The Pinellas County property appraiser and tax collector.
Okay. The property appraiser's records are on pages 103 through 105, and the tax collector is on page 106. Is that correct?
Correct.
Okay. This is information that you would have pulled off the website for this case?
Correct.
Okay. And can you tell us briefly why this case is here on the court docket today? Is there a violation of the city code?
Yes, specifically section 14-30. Section 94-80, section 94-81.
All right. There's also a violation of section 110-719, fencing?
Correct.
Okay. This property was brought to the city's attention as being a violation of the code by what method? Was it a complaint? Was it the property owner? How did it get to the city for this code violation?
The permit at the property had expired and work continued.
Okay. So is it something that the city staff went out and found that work was continuing on this property even though the permit had expired?
Correct.
Okay. All right. I'd like you to turn to page 107 in the packet that we have here today and point to your attention what is titled at the top, a notice of code violation. Do you recognize this letter?
Yes.
Okay. Can you explain what it is?
It's a notice to the owner letting them know that the property is in violation of the ordinances that were cited.
Okay. And what is the date of the letter?
September 10th, 2020.
Okay. And did it give a specific time frame as to when the city was asking the property owner to bring the property into compliance?
It was 2 weeks. The follow-up date is September 24th, 2020.
Okay. And is this letter signed electronically by you or by the building official?
Yes, the building official and community development director.
Okay. Did the property owner bring the property into compliance with the cited code sections by September 24th?
No.
Okay. Was there another letter sent to the property owner?
Yes.
And when was that?
September 24th, 2020.
And what was the purpose of that letter?
Letting the property know letting the property owner know the property was still in violation, and they were given a follow-up date of October 12th.
And the letter that we're talking about now, that's the letter dated September 24th, 2020?
Yes.
And that's in pages 110 through 112 of the packet?
Yes.
Was that letter sent by certified mail?
It was.
Okay. And in the packet, does it reflect the green card, a copy of the green card in the envelope showing that it was sent to the property owner by certified mail?
Yes.
That's pages 113 and 114?
Yes.
Okay. Now, you had mentioned in that last letter that you're asking the property owner to bring the property into compliance by October 12th, 2020. Was it brought into compliance by that date?
No.
All right. Was there another letter sent to the property owner then seeking compliance?
Yes, the community development director, Linda Portal, had sent a letter to the owners.
And that letter is reflected on page 115 and 116 of the packet?
Yes.
All right. And in this particular letter, it's asking the property owner to bring the property into compliance within a certain period of time. Looks like the letter says 90 days from the date of this letter?
Correct.
Okay. And was that letter sent to the property owner by
Yes.
certified mail?
Yes.
And is that reflected in page 117 that the green card was sent?
Yes.
Okay. Did the property owner bring the property into compliance within that period of time?
No.
Was another letter issued to the property owner to bring the property into compliance?
Yes, an additional letter was sent to the property owner on November 16th, again by Linda Portal.
Okay, and in this particular letter, it specifically references a meeting that had taken place on November 10th. And this is the letter that sets forth what the property owner would do to bring the property into compliance?
Correct.
Okay, and is that, was that sent by certified mail as well?
Correct.
Okay, and so that letter starts on page 118, it goes to 119 in the packet?
Yes.
Okay. If you could look at the next couple of pages in the packet, and maybe you can explain as you go through them what each one of these pages are by page number, and then explain what they are.
So page 120 through 125 is the building permit application that was originally submitted for the project at the property. And you can see the address, the property owner, the estimated cost of construction, and the scope of work.
All right, I'm going to stop you on that. So the estimated value of the work, this value, can you tell us where that's located? That's on page 121, correct?
120.
Okay, and what was the value of the job that was set forth on the building permit application?
$139,050.
Okay. And then, again, another question on this building permit application. What exactly was to be included in the building, for the building permit? What were they doing?
The scope of work was a second-story addition on the existing home, adding a new bedroom and bathroom.
Okay. And this application, it was signed by the general contractor?
Correct.
Okay, if you could move on then to page 126 and 127, explain to the special magistrate what these pages are.
So page 126 is an inspection field sheet, and towards the bottom of the page you can see the inspections that were done when, the result, and what type of inspection it was.
Okay, can you tell when the last inspection was done, approximately?
The last inspection was August 25th of 2017.
Okay. So was the work completed on that date? Or did the work continue after that date?
Continued after that date.
Okay. All right, if you could go then to the next page, page 128, and explain what that is.
The affidavit of service.
And is that to reflect that you had sent a notice of violation and notice of hearing to the property owner to be here at this hearing today?
Correct.
And you sent it by certified mail and regular mail?
And the property was posted as well.
Okay. And it was posted at City Hall too, wasn't it?
Correct.
Okay. So next in the documents, page 130 and 131, it looks like the notice of hearing. Is that correct?
Correct.
And the statement of violation follows that on page 134 and 135 and 6?
Correct.
All right. Can you explain, starting at page 137, what these documents are?
The page 137 is a picture of the posting of the affidavit of service, statement of violation, and notice of hearing on the property.
And the next letter That actually, November 10th letter, that was documenting what was actually said at that discussion on November the 10th with the property owners, correct?
Correct.
Okay. If you could turn to page, this is page 142. It looks like a photograph. Can you explain what that photograph is?
That's a Google shot of the property. I'm not seeing from 11/6/2020.
And so they've completely gutted the entire structure.
Correct.
Okay. So they've removed everything on the first floor, even though that was not part of the permit.
Correct.
The next document, starting at page 143, it looks like all the way to the end, 151. These were the plans that were associated with this project, building permit plans?
Right.
And these reflect the scope of the work that was supposed to be done on the property?
Correct.
And can you explain where that scope of work is on this document?
So right below existing floor plan, in the bottom and the middle, it's a little hard to read because of the size.
Okay, and this just reflects the addition of a second floor for a master bedroom and a bathroom, correct?
Correct.
Okay. All right. I don't have any other questions for Mr. Pinkert. I would tender in evidence these documents, 103 through 151.
All right, Mr. Trask, I'll go ahead and accept into evidence pages 103 through 151 as exhibit number 1 to today's hearing. Mr. Trask, I wanted to ask Mr. Pinkert, and if there's another witness that it would be better suited, that's fine. I just want to make sure I understand the nature of all of these violations. Mr. Pinkert, if you need to refer to others to answer my questions, that's fine. I understand that there are several violations that are being alleged here. The first is under Section 14-30. Is that violation essentially based upon the fact that the owner applied for a building permit and did not use the correct value of the scope of work?
Correct.
All right, and then the 94-80 violation, that's based upon work done on the first floor.
I would defer to either the building official or community development director.
Okay, no problem. The 94-81 violation, I just want to make sure, I see the violation here, I just want to make sure I understand what the owner did, if you can tell me to specifically violate that code provision. And if you need to defer to others, that's fine, I'll ask Mr. DeSantis or whoever else, city clerk.
I would defer.
Okay. In regard to the next violation, it says further action permitted due to unresolved violations. Do you know specifically?
We're not moving forward on that violation.
Okay, not moving forward on that one. Thank you, Mr. Trask.
Mm-hmm.
And then fencing, the Section 110-719 pool fencing. I didn't hear anything about that. You going to deal with that in another witness, Mr. Trask? Okay. All right. Thank you for bearing with me there, Mr. Pinkert. Okay. Is there any? I saw some hands raised that the respondents, property owners, are here. Who wants to come forward? Come on forward.
Good afternoon.
Good afternoon. Will you please give me your full name?
Alyssa Milby from the Deeb Law Group on behalf of Mr. and Mrs. Helms.
All right. And Alyssa, what's your last name again? I'm sorry.
Milby, M as in mom, I-L, B as in boy, Y.
All right. What firm are you with?
Deeb, D as in dog, E-E-B as in boy, Law Group.
All right. Ms. Milby, this is your opportunity to cross-examine Mr. Pinkert. As you saw in the other hearings, I'm going to give you the full opportunity to call your own witnesses. and everything else like that. This is just the opportunity to cross-examine Mr. Pinkert. You have any questions for Mr. Pinkert?
With respect to Mr. Pinkert's testimony in particular, no, I do not have any questions at this time.
No problem. We'll let you back up with who Mr. Trask calls next.
Excellent, thank you.
Mr. Trask, who are we going to call next?
I'm going to call the building official, Mr. DeSantis, please. Mr. DeSantis, you've been sworn in earlier today. Could you state your job responsibilities here at the City of Madeira Beach?
I am the building official for the City of Madeira Beach, and my job is to administer the building codes, Florida building codes.
You're familiar with this property?
Yes, sir.
Okay, and the property I'm referring to is 546 Johns Pass Avenue, correct?
Yes, sir.
Okay. When was your first involvement on this property, approximately?
As far as issuing the permit?
Yes,
or,
sir.
The permit? The permit was issued on October 18th of 2016.
Can you explain to us all what was asked for? Mr. Pinkert did it briefly, a general version, but can you explain what the property owner was attempting to do and what the property owners were given the permission to do under this building permit?
The building permit, the scope of work on the building permit was to build a second floor bedroom and bathroom, and what occurred was when they demoed the property, they took the roof off, and when they went to put the roof back on, they finished out the first floor without a permit. That wasn't part of the scope of work.
Okay, so briefly then, it was your understanding that when this permit was applied for, they're just going to take off the roof, they're going to add some type of flooring, they're going to put a second floor on, add a bedroom and bathroom, put another roof on, that's the job?
Yes, sir.
Okay. And the value of the job has already been testified to as being $139,050 as to what the applicant had put on the permit. And is that ultimately what the value of the work that was done, or was it something different than that?
It was different from that value.
Okay. Why is the value of the project important on this particular house?
Because the house is regulated under FEMA because it's a slab-on-grade house. It's pre-firm, meaning that it's regulated by FEMA. Every square foot of the house is regulated by FEMA's rules. Okay. And Ms. Portel can explain a little bit on that, being the floodplain manager.
Okay. So is there some type of city regulation or code provision that says that they cannot do this type of work if it exceeds a certain dollar amount or percentage?
Yes, there's a FEMA rule, 50% rule.
Okay. Can you explain that to us?
I can explain it to you briefly.
Okay.
The FEMA 50% rule goes by the value of the structure only, and the total value of the structure divided by 50%. You cannot exceed that in rebuilding or remodeling your house.
Okay. And in this particular project, at the value of $139,050, that would have been acceptable, correct?
Yes.
But if it was over that value, it would not necessarily be acceptable, correct?
Yes.
Okay. So I had asked you when your first involvement was, and you had said October of 2016. In the packet that has already been received in the evidence, it reflects on the inspection field sheet, which was printed out on September 10th, 2020. It's page 126 and 127 of the packet. It reflects inspections that had been done in 2017. Do you have that in front of you?
Yes, I do.
Okay. Can you explain why there were no inspections after August of 2017?
There was no inspections after that because the contractor did not call any out. There was an absence in the building, and we did our daily routines, and we drove by, and there was no work being done for a large period of time.
Okay. So when did it come back into the city's focus? What year? And why did it come back into focus?
It came back into focus last year, and the reason why is because when we, our permit expires within our software, it brings up an alert to us to act on it. That's how we got the notice.
So did someone go out to the property to determine whether or not the work had continued?
Yes,
And who was the person that did that?
myself.
Okay, and what did you determine when you went out to the property after you got that permit expiration notice?
There was a lot more work that was done beyond the scope of work in the permit.
Okay. So did you put a stop work order on the project?
Yes.
Okay, and what's the purpose of a stop work order?
The stop work order, the purpose of the stop work order is to stop all work on the job till it's resolved. No contractors, should be on site till it's resolved and activated.
Okay, I want to bring your attention now to the code violations that were cited in the notice, and ask if you could explain those, each one of them, as we go through it. Well, first of all, let me back up. In the packet, there are some schematics that Mr. Pinkert referred to. They were on pages 143 through 151. You have those in front of you, sir?
Yes.
Okay. Would this have been the plans that would have been attached to the application for the building permit?
Yes.
And I can't read that down there. Can you tell us what it says as to what the scope of the work is?
Kind of blurry down there. Scope of the work, the initial scope of the work was a demo of the existing and to install a new second floor, provide, and I'm sorry, a lot of it's blurry. Framing to the second floor, and I'm sorry, that's all I can read off these plans.
Okay. But when the building permit was applied for, it was specifically, though, for the second floor bedroom and bathroom and nothing else, and that's what that scope of work says if it was blown up.
Yes, that would be on the second page of the permit also.
Okay. So what I'd like to do is just to go back now and talk about the code violations that have been cited for the property, and if you could explain them to us. I want to start with Code Section 14-30, and then there's two asterisks underneath it, if you can explain what that particular violation is for this property.
Section 1430 is the administration of the Florida Building Code, and that's referring to the scope of work that was on the permit, and the asterisk itself is for the Florida Building Code 6th edition, 2017, and it states in the Administrative Code 109.3 the building permit valuations.
So they were cited because of the fact they underestimated the value of the work that was done?
Yes.
Okay. So they're specifically required under this code section to tell you what the value of the work is?
Yes.
Okay. And the second asterisk refers to Section 110.1, General, also under Section 14-30, Administration of the Florida Building Code. Can you explain what that violation is on this property?
Sorry. The second asterisk is the Florida 6th edition, 2017, Administrative Code 110.1 General. It's for construction or work which is permitted and is required shall be subject to the inspection by the building official, and such construction or work shall remain accessible and exposed for inspection purposes until approved.
Okay. Is that what happened on this particular project? They left everything open for inspection before it was completed?
No.
Okay. At what stage of the house is the house right now?
Right now, it's finished, from what I understand, completely finished.
But they didn't call for any inspections from August of 2017 through the date when the first violation notice was sent in September of last year. Is that correct?
My last inspection was August 25th. It was a failed inspection. August 25th of 2017.
Okay. All right, these other violations, 94-80 and 94-81, is that something more particular that the planning director could help us with?
Yes.
All right, can you tell me about the fencing violation? Why is there a fencing violation on this property?
There's a fencing violation on this property because they didn't provide a fence around the swimming pool that was remodeled. There's a construction fence. The last time I was there was a 4-foot orange construction fence around the pool, and when I visited or took pictures, there was no fence, and they were using the pool.
Okay. So, there was no final building inspection,
Nope.
correct?
No.
There's no certificate of occupancy.
No.
These people are living in the house currently,
Yes.
okay? And they've been living in the house for how long that you're aware of?
Gosh, it's got to be at least a year.
Okay. So is the property still in violation of the sections that you and I talked about today, 14-30, paren A, and references to the Florida Building Code dealing with the permit valuations and no inspections?
Yes.
Okay. Okay, I don't have any other questions of Mr. DeSantis. I'm not sure if there's any cross-examination.
Ms. Milby, come on up.
Thank you. I just have a couple of follow-up questions.
Go ahead.
Can you speak into the microphone?
My apologies. Is that better?
Yeah.
Mr. DeSantis, you state that the permit was issued in October 18th of 2016, correct? And
Yes.
and with that permit, you've already discussed that the permit application would have included the plans that begin on page 144 of the documents that have already been submitted into evidence. If you don't mind turning back to that.
I'm sorry, 144?
Yes, sir.
Yes.
Okay, and this is the building plans that were submitted, the left stating new second floor plan and the right depicting the downstairs, which states new floor plan. Is that an accurate depiction of what you're looking at?
Yes.
Okay. What from this document would make you think that it was only the second floor being renovated?
What from this document?
Yes, sir.
The new construction on the second floor.
Understood. And if the bottom floor, the downstairs, that being the right portion of this plan, if the downstairs was not going to be renovated, why would that have been included in these plans?
I don't know.
Did you inquire further into that, or did you just assume the downstairs was not going to be renovated?
I went by what the scope of work was on the permit.
But this is part of the permit application, correct?
Yes, it is.
And you would depend on this document when issuing the permit, correct?
Yes.
Understood. Additional question, and you stated you did all of the inspections in 2017 that we've previously discussed at the property, that's correct?
I did not do all of them. I had the county inspection folks helping me at that time, so there was a couple of them done by the county folks.
But you stated following 2017, and please correct me if it's a misstatement of your testimony, but I believe you stated that there was no additional requests for a final inspection?
No.
Is that based on your recollection, or have you reviewed any records to confirm that?
I have all the permit inspections in front of me for the entire period, and there was no inspections requested after that.
I understand there are no documented inspections, but do you have anything in front of you, or did you review anything prior to today that would reflect whether anyone requested a final inspection?
No.
So you cannot state definitively that there was no request for a final inspection?
There was no request for final inspection.
Based on your recollection?
Yes.
Understood. And you state that it is your understanding that the home is finished. What is that statement based upon?
My last walkthrough with one of the superintendent's crew did.
My apologies, please continue.
It's one of the employees for the construction contractor.
Understood, and when was that?
I don't remember. Do you remember? I don't remember. Honestly, I don't know off the top of my head.
Would it have been in 2017?
No, it was last fall.
My apologies, I believe you stated there were no additional inspections after 2017.
Nope. No, there wasn't.
So you were at however, you were at the property last year?
I was at the property last year because the contractor called me to the property last year because there was a problem with their pool, and that's why I was there.
Understood. So you were at the property after 2017?
Yes.
Okay. So your recollection of the property being finished is based on an inspection that occurred a year ago?
Yes.
Okay. So you have no other personal knowledge in that regard other than that inspection?
No.
Understood. And with respect to the fencing violations, are you aware that a fence has not been constructed because the homeowners have been unable to get a permit from the city? Do you have any knowledge on that?
Yes.
Okay, can you dive into that a little bit further?
They applied for a fence for their pool, around the perimeter of the pool, and we did not issue a permit because there was an outstanding code violation. At the time, there was a orange construction, 4-foot construction fence around the pool, which was still under construction.
Understood. So the fencing permit was denied because there was ongoing removal work that was currently taking place. Is that correct?
No.
Okay. Can you please explain why the fencing permit was denied?
The fencing permit was denied because there was an open code violation.
Being
the permitting problems within the house. There was an open code violation for the permitting problems within the structure, so with an open code violation, we would not issue another permit until that was resolved.
Understood. So in light of ongoing permitting issues, the homeowners were unable to resolve a permitting issue.
Can you repeat that one again, please?
In light of ongoing, as you claim, permitting issues, a permit was not issued so that my client could resolve. Basically, the pre-existing permitting issues prohibited my client from getting
a permit, fence permit, yes.
Okay. Are you aware? So ultimately, would it be based on prior knowledge in situations like this? They would need to resolve the prior issues before qualifying for a permit for the fence?
Yes.
Okay, understood. And what prior permitting issues are you referring to specifically that would need to be resolved?
Well, the permit itself for the construction inside the house.
And is that with respect to the FEMA issues we've discussed?
Yes.
Okay, understood. So those issues need to be resolved, and then a permit would likely be permitted to be pulled for the fence. Understood. I don't believe I have any additional questions at this time.
I just have a few questions, so just hold off on your redirect here. Ms. Milby, stay close. I just want to make sure I understand that I've got this right. I'm looking at from page 120 to page 125 appears to be the original permit application. Is that right, Mr. DeSantis?
Yes, that's correct.
And Ms. Milby asked you some questions about pages 143 through 150. And I see something highlighted on there. I don't know whether that says scope of work or whatnot, but what are pages 143 through 150?
Pages 143 through 150 are the set of plans. They're a 24 by 36-inch set of stamped plans by the architect.
Okay, and these plans would have accompanied the building permit number 1017?
Yes.
All right. Okay, I just want to make sure we're all on the same page. Mr. Trask?
I have a few questions.
Hold on, Ms. Milby, do you have any questions based upon my questions of this witness?
I don't believe so.
Okay, Mr. Trask, go ahead.
So, Mr. DeSantis, I want to back up. With regard to the inspection process, there's more that needs to occur than a, quote, final inspection, correct?
Yes.
Okay. Can you briefly tell us what inspections need to be done? We're talking electrical, mechanical, structural, drywall, roofing. What needs to be done besides the final inspection?
Well, there's multiple final sub-inspections, and you're correct. There's a roof final, a mechanical final, electrical final, plumbing final, framing final, insulation final, and drywall final. Those all need to be done before the building final.
Okay. And is it possible to do those the way that the structure is right now, or is there going to require some of the drywall to be removed to determine whether the plumbing is accurate and the electrical is accurate?
Yes.
Okay. So it is not a matter of just walking in the house and basically approving all those inspections just by one walkthrough, correct?
Yes.
Okay. Now, with regard to this plan review set, is it often that people provide you with plans that encompass something that's going to happen in the future versus what they're actually going to do today with regard to the current application?
Yes, I can get plans, multiple plans from folks, and they'll have future renovations.
Okay. So you can't necessarily rely upon the schematics. You have to go to the scope of the plan or of what is actually being done versus the schematic shown in the plan, correct?
Yes.
Okay. And we know for sure that this application was for a second floor addition. It didn't refer to anything at all in the application to first floor remodel or replacement, did it?
No.
Okay. All right, thank you. That's all I have for Mr. DeSantis.
Ms. Milby, any last questions for this witness?
Just a couple, if that's all right.
Great.
Going back to page 126, it's the inspection field sheet. We were previously discussing, it reflects the inspections that took place in 2017. I see here there were several that took place. So during these inspections, when did you realize that there was work being done on the first floor?
When during the inspections?
Yes.
Almost immediately, right after the initial work started.
Were the homeowners made aware of this?
No, the contractor was.
The contract, do you have anything in writing reflecting that?
I have a stop work order that was issued, along with several pictures.
What date was the stop work order?
What date? I don't have the stop work order in front of me, but the pictures are dated. That went along with the stop work order, and they're dated for 3/13/2017.
But then inspections continued after that?
Yes, after it was resolved.
And what do you mean by after it was resolved?
The stop work order was issued, and the contractor was requested to come into City Hall and discuss what was going on with the project with the floodplain manager at the time.
You mean, what's going on with the project with respect to the scope? To
Yes.
clarify that it was also the second floor?
Yes,
So that was ultimately resolved.
yes.
Thank you. No further questions.
Mr. Trask, I know I've let this go on, so I'm going to give you the last opportunity to question, Mr. DeSantis.
No further redirect?
Okay, thank you.
Thank you.
Ms. Trask, yeah, you going to call another witness?
Yes, I'd call Ms. Portal. She has been sworn. Ms. Portal, can you
Yes.
briefly tell the special magistrate what your job responsibilities are here at the city?
I'm the Community Development Director and the Floodplain Manager. I administer the planning ordinances, all the land development regulations, and also that includes the floodplain ordinances, and also manage the community rating service or system in cooperation with FEMA.
Okay, so are you the floodplain manager for the city then?
Yes,
Okay. So you're familiar with this particular project that we're talking about today?
yes,
Okay, and you've been involved with this project since the fall of last year at least?
yes.
Okay. And what was your first involvement with this property?
I was first notified by Mr. DeSantis that the project, there have been additional activities and building on the project that they had cited them, that the project did not have, it had more work done than the plans had been approved, the scope of work, and that they would require a new set of plans with details of what that work included in order for them to move forward and to get the permit to move forward with this new work, but that it did potentially change the value of the job.
At some point, did you or someone in the city determine what the value of the job as completed as of when as of last fall when you first got involved in this?
Yes, that's normally part of my responsibility is to determine what the value of improvements are to see if they trip the kind of measure of a substantial improvement. And that is the improvement that goes over 50% of the value of the original structure before improvement. So we use standard numbers from the ICC manual indicating the value of area depending on the way that it's improved, and then apply that to the renovated structure to determine if the work being done has a higher value than 50% of the original property appraised value.
So did you determine what the original property appraised value is and what ultimately the work resulted in, the value of the property, the value of the remodel?
Yes. Initially, and it would have been very difficult for them to have been under 50% of the value because they doubled the size of the house, and it was a lot of new construction, which has a higher value than renovated structures. And so we counted up the floor area of the new construction and valued that at a new construction number, and then added that to the renovation of the entire downstairs at various rates depending on how that space was used, and determined that the overall job had a value higher than 50% of the appraised value. That value includes, it's actually how much the real value of the house has improved. It's the market value. It doesn't pertain directly to the cost that the homeowner expends or that the contractor is willing to work for. It's an overall value.
Okay, so what was the value of the home when the building permit was originally issued, and what could they expend without hitting the 50% substantial?
The original estimates were based on just the addition of the upper level, the amount of work that had to occur downstairs in order to support that new work on the second floor for the addition of a bedroom and a bathroom. So that would include, of course, some changes downstairs due to stairs and access requirements. And that was all valued at, I think, $138,000. Excuse me, yes, 138, which was right in line with the 139 that the contractor had estimated for the work on the original scope.
Okay, and how much work in value did they actually do to the project when it was completed?
When the project was completed, it was, excuse me, let me make sure that I quote the numbers correctly. The total value was $222,114. This exceeded the maximum allowed of the 159 that they could have used by $62,914.
So the bottom line is that they exceeded the dollar amount that they could by $62,914 in value.
Correct.
Okay. So with that understanding, did you issue, well, first of all, have you met with the property owners?
Yes.
Approximately how many times?
Well, we've had group meetings, I think 3 times. Also, I've been in touch with them since then, almost, at least every other week, either one or another of the property owners to discuss their progress in meeting the conditions they had agreed to.
Over what period of time?
Starting with the November meeting until just this last week, or the week before.
I'm going to bring you back to the letters that have already been received into evidence, and there was a letter, and it was issued by you on October the 12th, 2020, to the property owners. Yes. And that's shown on page 115 of the packet. Do you have that in front of you?
Yes.
What was the purpose of this letter to the property owners?
The purpose of this was to notify them that in the review of the work, it had been determined that the amount of value that had been added to the home was more than 50% of the original value of the home, and given that the requirements for floodplain management and FEMA and the building codes combined would require them to take one of 3 measures to correct it. The existing structure with its remodeled first floor, the new second-story addition, and the mechanical equipment could be lifted to a height 2 feet above the base flood elevation.
Okay, let me stop you right there.
Okay.
So the first option was for them to raise the house.
Yes.
Okay.
The second option was for it to strip the finished improvements out to a level that got them back down to the 50% value. The first floor of the home could have been stripped out and then made into a garage, effectively garage and storage space, of which not 299 square feet was enclosed, and they could build on top of it with or just use the second floor or alter it in some way, effectively making a post-firm house that met the requirements for elevation.
Okay, so for us, people that are not in planning, you're basically saying take out all the bedrooms and every other division of the property, of the first floor, and just basically make it open area for storage for cars and so forth? Yes. Okay. But they could keep 299 square feet of enclosed area to put certain things in?
Yes, but it have to be storage.
But it would not be livable space?
No.
Though. Okay. All right, and the third option?
Was to demolish the entire structure.
Okay. Once this letter was sent, did you receive a request to meet and discuss this from the property owners?
Yes, we did.
Okay. And did you, in fact, meet and discuss it with them on November the 10th?
Yes.
Okay. And can you tell us who was at the meeting on November the 10th?
On November the 10th, we met with Mr. and Mrs. Holmes and with their contractor.
Okay.
Oh, and I believe that they had asked that the mayor sit in as well.
And who else is in the room besides you and the mayor from the city?
The city manager and Mr. DeSantis.
Okay. And so during this meeting, was there some type of resolution that was discussed?
Yes, they had hoped that there was some way they could get to a point of making changes to the existing improvements to remove enough of the value so that they could stay in and continue to use the house, not lose the whole thing by taking out that extra value. That's something that FEMA does allow, and so we agreed to try to measure out the value of every little piece of it to see how much would need to come out to get them back down to that value, that to remove that $62,000 extra value from the house.
Now, they could have done that and provided that to you for you to review and decide whether or not that was appropriate, but they didn't do that, did they?
No.
And in fact, you took it upon yourself to go the extra step and spend the weekend and to figure out what they could do to resolve the issue, correct?
Yes.
Okay. And is that what resulted in this letter of November the 10th?
Yes, that was me trying to figure out ways to make it work.
Okay, so with this letter of November 10th, it was sent to the property owner?
Yes.
Okay. And can you briefly explain what is being discussed in this letter? I understand that the special magistrate can read this letter on his own, but there may be questions that come out of this, so can you explain what you're telling them, what they can do to get it in compliance?
Yes. What I needed to do was to, as I said, separate all the various parts. There was new construction that had value, renovated areas that had other value, and then we also use open spaces at a still different value, like porches or garages has a reduced value. So I went through and assigned value to all of those areas and then made proposals on things that could come out or at least made them available as proposals by separating and giving them values to look at. So I try to be really careful because there was actually some improvement to the ground floor. As I said, that was natural to the second floor addition. So I made sure that they got credit for that as part of the original program or the original project. For instance, there was added height, new ceilings and things added to the garage and the front bedroom, but that had to be done in order to support the upstairs. So some of that kind of construction was attributed to the second floor addition.
So in layman's terms, you're giving them the benefit of that and
Yes.
not including it in the price differential.
Correct, as being part of the first work that was done. And then we broke down parts and pieces. A lot of the downstairs is just open space, really. Those are all improved areas, but as opposed to counting everything by a renovation cost per square foot, we went through and broke out the cost of the electric and the mechanical in the walls and the wall boards to try to, reduce the costs that they were charged against them, but also give them the opportunity to take some portions of things out individually in order to get down to the number they were looking for.
Okay.
So these are all broken out. Initially, I specify that what the values of all of the different parts were, and then on the first floor, the unpermitted work specifically, I broke out into different line items and provided the calculation, the formulas used to calculate those.
Okay. And then in that same letter, did you tell them what they had to do, or what was a suggestion for them to do to
Yes, this one.
allow the CO to be issued?
This one also is the letter that gives you the breakdown and exactly how much money they're looking to find in the project, how the original estimates were put together, and just the history of the values. We did use also values, square foot values and cost values from the original project date, which was 4 years back, instead of using current numbers because those are much higher. And even went to the point of research to make sure that we understood what the cost of mechanical improvements were in that time as opposed to what using current project numbers now.
Okay, so to finish off then on this particular letter, you gave them a list of steps that you believe were necessary to bring the property into compliance. That's on page 140 of 151.
Yes, and we went over all of this in detail, and they even suggested of their own volition at the time that they had there was a big value in the kitchen, and asked, if really could they get the number up that they needed by taking out the kitchen. Another thing was we discovered at that meeting that the plans we had been provided for the improvements, the new plans that were supposed to include all of the improvements, did not actually include the back porch. There was an additional porch that was constructed off the second floor that was not in the plans, even the ones we had in front of us at that time. And it had been, we'd had to measure it out on site to figure out what its value was, because obviously it was additional construction value that had to be removed in order to get us down to that final number. And so we went back and forth over the various sections and their value in order to get to the point we could reach the $62,000 and come to an agreement on which things they were willing to do or that they could feasibly do to save the house.
All right, so after they received this letter of November the 10th, you had discussions with the property owners and they agreed to do certain things to bring the property into compliance, and those are the items that are listed out on your letter of November 16th, 2020, correct?
That's right, yes.
So that's page 118 and 119 of the packet. So in looking at that letter, to reduce the value by that $62,914, they needed to remove the kitchen improvements, all but the sink and one base along the newly constructed northwest wall. They needed to remove 6 double French doors, 3 on each floor, valued at $30,000. Finish the interior and exterior walls sealed to qualify for the CO. Take out the closet improvements on the first floor by removing both the master and pantry closet, interior, all shelves, racks, and et cetera. That was a value of $7,140. And in the small bathroom on the first floor, all the improvements in the master bathroom on the first floor are going to be removed except for the shower. That was a value of $5,422. So they need to do that. In addition, they needed to do the other things listed in the letter, such as the signed and sealed survey, get the permit, pay the building permit fee, and submit signed and sealed letter from the project architect verifying all the improvements were constructed and installed according to the Florida Building Code.
Correct.
I know I paraphrased a lot of that, but they agreed to do all of those things to get it into compliance.
Yes.
Okay. So now we're in November of 2020. Have these things been done?
They did some of them.
Okay.
And I haven't spoken to them since a week ago Friday. And during the course of last week, one day when I was out, I understood that they had received a message that they were going to be removing some more of the improvements, but I haven't received anything indicating that all the work has been completed, and all the pictures that have been shown or provided up to this date show parts of the improvements removed.
So can you give us an example of what you mean by parts of the improvement?
Sure.
Let's start with the kitchen improvements, $20,976. Have they removed everything but the kitchen sink?
No, they removed the upper cabinets but left the lower cabinet, except they removed drawers and doors from the cabinets on the lower part. That includes, last I saw, that included leaving all of the granite work. Also, in the kitchen there's a large island, And initially, they were planning to just move it out for later, but said it was too heavy to move, so they did not remove that. So the kitchen was only partially deconstructed. They were to leave a sink and counter space, and we had agreed ahead of time what portion of that could remain, because those are the two pieces that are required to qualify a house for CO, for occupancy.
Okay. So the 6 double French doors, have they removed all 6?
I don't know that they removed them. My understanding was they were going to be removed, and we talked about it, about how they would have to finish out the walls, and as if the doors hadn't been there. The pictures that we got showed plywood across the doorways, and they were framed, and it was framed in, but it did not indicate that the doors had actually been taken out. It looked as though they had more or less been encased in the plywood.
Okay. The closet improvements on the first floor, have they removed the master and pantry closet interiors, all the shelves and the racks?
They removed the shelves and the racks. Any place in a closet or in a bathroom where they had granite, the stonework remained, and the base cabinetry.
Okay, so it's not been completed there either.
Right.
And the small bathroom on the first floor, remove all but the shower. Have they done that?
No, because last I saw, it still had base cabinets and the granite and sink.
Okay. Have they provided you with a signed and sealed survey with scale to indicate the proximity of the expansions to the property line?
Yes, we did get that.
Okay. Number 3 was existing building permit extension, substantial completion packet, and the permit application must be amended and resubmitted to include all new detail for review, including updated plans, signed and sealed survey to scale. Have they done that?
No, we would need a new set of plans that showed all of these things removed, and we don't have a set showing what's been done.
Okay. And have they paid the difference in the building fee? Number 4?
I would have to defer to the building official for
Okay,
that. I don't believe so.
he can't answer that question now. If you don't know, we'll just leave that alone. So, item number 5, the contractor submit a signed and sealed letter from a project architect verifying all improvements were constructed and installed in accordance with the Florida Building Code. Has that been done?
No.
Okay. Is it the city's position that once they do these items in this letter that they already agreed to, that they would be in compliance, and then they would be able to get the building permit for the fence as well?
Yes.
Okay. Thank you. I don't have any other questions.
Ms. Milby, come on up here. Ms. Portal, I just have a question. There's one page 151 out of 151, that looks like it has some numbers on it, but I'm having real difficulty reading these. Can you explain what this page of the agenda packet or exhibit
That was
1 is?
a page of notes that was created by Michelle Orton. She was the floodplain manager at the time. It was just attached to her review of the plans originally, and it showed that she was using numbers that reflected just the ground, or just the second story. It's because even for her, it's not unusual that people will come in with future plans. We have to go by the scope of the work and value of that.
Understood. So those are mathematical calculations
Yes.
prepared by Ms. Orton, and that's what she ultimately, or I think you included in the letter
Yes.
that she came up with. All right. Thank you.
I skipped 2 things that I needed to cover. Can I do
All
that
right,
before we do that?
We'll go ahead before you come up, Ms. Milby, but
Sorry.
continue to stand there.
Okay. That's what I was going to ask.
All right, so with regard to the other 2 code violations that were not testified to by Mr. DeSantis, I want to go over section 94-80 violations and 94-81 and ask for you to explain to us why this property is in violation of those 2 code sections.
This addressed the building or structure without the documentation of elevation of the lowest floor or required design certification or other evidence of compliance with chapter of the building code that deals with flood areas and with elevations, pertaining to FEMA and its requirements. That the information that was provided to us, was, actually, we didn't have information on the design, the exact design details of what went into the ground floor at all, since there were no specs provided for ground floor work.
Okay. And with regard to 94-81, what is the violation there?
This is based on the fact that the floodplain administrator has to authorize the work under the Florida Building Code, that section of the code that we administer dealing with flood-prone areas and building in those areas, and that wherever it's shown that violations have occurred to that work, that the floodplain administrator must notify the building official and the owner and agent to be sure that the work is stopped and what has to be done to get them back into compliance.
All right, thank you. That's it.
Hold on, Ms. Milby, real quick. I just want to make sure I understand the violation under 94-80. It was because work was done without documentation of the elevation of the lowest floor. Is that?
Well, that's only one of the issues listed there. Building structure without the documentation and elevation for the lowest floor. And of course, we didn't have all the documentation for that lowest floor. And also, other design certifications or other evidence of compliance with the rest of the building code.
Okay, so it's not that work was done without a permit, it's they didn't submit the necessary information to issue a permit?
Correct. They had a permit for some of the work initially, but for the work that was, a good deal of the work that was done was not permitted, it was not reviewed in compliance with the building code.
All right. Ms. Trask, I'm going to give you a chance to ask some questions in a minute, but Ms. Milby has been standing by patiently. So, Ms. Milby, this is your witness if you want to cross-examine.
Thank you. I just want to turn back briefly to the November 16th, 2020 letter that you were previously discussing with Mr. Trask. And is it correct that your testimony was that if the items in this letter are addressed, that this would resolve the current violations alleged against Mr. and Mrs. Helms? Is that correct?
That was what the intent of the letter was, yes.
Understood. And on page 119, that's the second page of the letter, that last paragraph here, the states, if there are any questions about the intent or instructions contained in this letter, the City of Madeira Beach Floodplain Manager shall be the interpreter and final authority on the matter. The city will communicate with both the owner and the contractor throughout the permitting and review process and encourage the owner and contractor to communicate any questions to the city floodplain, sorry, you guys, City Floodplain Manager for efficient and complete response. And the City of Madeira Beach Floodplain Manager, that would be who?
Me. That's me.
That would be you. And how would you characterize your responsiveness to Mr. and Mrs. Helms throughout this process?
I've met with Mr. and Mrs. Helms. Every time they've contacted me, they come over to the city. They've called regularly, and we've talked on the phone several times. I've taken time out whenever they come in unexpectedly, and we sat down usually in this room where we had some time, and because it's an unscheduled meeting, we don't have a lot of meeting space, but we've come in here several times to go through details and for them to express their concerns about the work that they had to do and problems that they've addressed in the process.
So you would say Mr. and Mrs. Helms have each been very communicative with you regarding any questions they had about this plan indicated in this letter?
They, as far as I'm aware, they have communicated with me. I can't speak to questions they didn't ask if they have other issues.
Right, but they've been transparent with you throughout the process.
Well, I have understood what they've said to me. I don't know what all they were, I can't say what people were thinking and whether it was completely transparent.
Understood.
They will, well, anybody who's going through a construction project is going to see things and maybe describe them differently. And sometimes we've gone back and forth between who I was talking to and their approach to describing what was going on, but I've been as responsive as I was able.
Do you recall a conversation on March 12th? Mrs. Helms arrived at this office here, waited about an hour and 40 minutes, and you all had a conversation regarding the remaining issue of the kitchen marble. And do you have any recollection of that conversation?
Yes, of course.
Okay. Can you kind of give us a summation of what you recall occurred?
It's actually a conversation I'd had before. They had a great deal of concern about removing the granite throughout the house, not only in the kitchen but in other locations, bathrooms and other places where it's located. Actually, especially one of the ones in the bathroom, Mr. Helms had described as being more fragile than the kitchen granite, but that they were concerned if they moved it that it might break, and their contractor had told them that this was a risk, and they were obviously very concerned about that. We talked about, they had asked me repeatedly if there was any other way that things could be calculated, or if we could accept pictures of how things were built part of the way through the project, and then just be able to give them a CO based on where it was at a different stage than it is now, so that they could go ahead and pull a new permit for the rest of the work and not have to do what they had agreed to do, because they didn't realize initially that it was going to be that complex. And I assured Mrs. Helms, as I had Mr. Helms on several occasions when we talked about this, that I was very sympathetic about the concerns. I just couldn't find anywhere else in the project to take the value out. We had calculated every piece that could have a value at this point in order to get to that $62,000 and give them the opportunity to complete the project. And this is always with the understanding that once they had completed the project and they received their CO, they could come back and pull another permit to put the rest of the improvements back in the house, because at that point they would be granted another 50% of value on the new structure. So, but they were very concerned and did not want to remove the granite for that reason. Mrs. Helms also noted that it had cost a lot of money to get the part done that they had already done. She didn't want to unnecessarily spend any additional money just to finish it up. That it would cost additional money to even go further, and then she'd still have to pay to get it all put back later. It's understandably a very difficult situation.
Understood. And following that March 12th conversation regarding the kitchen granite, were you ever able to give Mr. or Mrs. Helms a definitive answer on that issue?
I told them each time that I couldn't find any other way to come up with the value. I don't recall the timing or the exact telephone conversation. A lot of times that we communicated by phone instead of in writing, but I told them each time I could not come up with the value any other way.
And as far as the items or the status of the removal that you've testified to, what is that based upon?
So far, it's based upon the reports that I got and the photographs that the Helms had provided me. We have not been called back out to review it as being completed. We also met with the contractor about 3 weeks ago, and he said that he had been headed out there to verify that everything was done so that he could bring the rest of the documentation back in, and he never came back and did not contact us to let us know that the work had been completed. So we were waiting to get a call from them to come out and show us that the work had been completed so we could keep the process moving, but I have not received that call.
Are you aware that the homeowners were diagnosed with COVID in February?
Yes, which is why we asked to continue the meeting and not meet in February.
Understood. And just for the sake of presenting something visual here. I do have some current photographs of the status of some of these items. As you can see, severe removal has occurred. I mean, they're clearly and I would submit these into evidence, they're clearly making every effort here. And from what you've told me, correct me if I'm wrong, they have been cooperative and they are trying to comply. From what you've told me, it would seem they're making every effort to figure out a way to comply, but also do it efficiently and in a way that...
They have come in repeatedly saying they really want to comply, they really want to resolve this, they need to get their permits, and obviously want to get the house put back together, but they didn't want to do that last piece of the work that was necessary to get the rest of the improvements out because of concern for the quality of the granite. And again, I'm glad to see they find a way to move the next step forward, but we hadn't been notified that they were ready for us to look at it, and it appears, at least from those pictures, that there's still some work to do.
Understood. And do you recall blueprints, revised blueprints, that is, as requested by you, that were submitted by Todd Feldman, the contractor, in November of 2020?
I do recall some revised plans, yes.
Okay. Do you recall whether you or someone in your office advised him that they had actually been lost by the city?
I do recall that during, I think he had turned them in much earlier than that. Actually, had turned in some plans at some point during the time I think we were in quarantine, and they had been misplaced. We were able to locate things later, but he had provided us with another set in the meantime.
So it's fair to say losing blueprints might delay this process a little bit.
No, I don't see that. We haven't had to review them because we haven't gotten the final work done. The whole point in those is that we have a set of plans that reflects the removed work so that we can stamp off on it and say that the house, under this situation, the current situation as described by those plans, meets the FEMA requirements in our own floodplain and building code requirements for a house that's appropriate for CO, but it does not exceed the 50% value. So we couldn't really review those until the work was done, and at this point we've been waiting for that work to be completed.
Understood. But the revised plans, which you stated they were, or you agreed with me when I said they were requested by you, so I mean it would be understandable to think that might delay work moving forward as far as what was actually being removed. No. As I said, they were not held up by that because those plans came back in November and we're sitting here in March still waiting for the final work to be done. The only thing that's held it up is that they have been unable or unwilling to take the rest of the improvements out. And we've been trying to be really patient. We didn't move forward to the magistrate, trying to give them lots of time because this is a big project. But it's something that was critical that we do get in place as soon as possible because it affects the entire city. Something we get in place, you are referring to the blueprints? I am referring to the finalized project and a CO on a house that meets all standards. Understood. And then what was the purpose then of asking for the revised blueprints back in November if those weren't really necessary until the project was complete? Well, we thought they assured us they were going to move forward with this, and we did not imagine it would take this many months for them to go ahead and make those changes and remove the things that were there. If we had everything done and they said they were completed and we realized we didn't have the plans, we would have asked for them immediately, and he was able to produce them immediately. It didn't require any kind of delay at all. Understood. Let me rephrase my question. It might not have been clear. If the plans were not an immediate thing that was needed, why were they requested that early on back in November? Because I gave them a complete list of everything that was required by the end of this effort. A complete list, which included obviously having the plans. It also states that they would pay the revised building permit fees and any administrative costs, and we couldn't calculate all that up until we had the plans done. We knew what had come out for sure, what the value was, and that everything was tallied. But obviously, I wasn't going to
bit and pieced them a list of things that they could do as they went along. They needed a whole list all at once.
Understood. So really, the misplacement of those plans was just due to the fact that, I believe you said a quarantine was in place at that time, so everyone was working from home?
We had people coming in a couple times a week. We also had some staff turnover in the meantime, and we were trying to be able to keep people moving throughout the city as best we could under the circumstances. But
right, doing the best you can do.
We were doing the best we could do.
It was a weird year, so I understand. So understandably, a massive project like this involving multiple parties, it might also slow down that project as well.
Which is what we've considered all along, especially when we heard that that the Helms had contracted COVID. That was very frightening, obviously, and we postponed everything, put everything off for at least a month to make sure they had time to heal. But yeah, this has been a long process. The amount of work that's been done could have been done in a much shorter time frame, perhaps in another year, or when times weren't so difficult. So we have been actually very flexible trying to help out with this.
Understood. And your statement that the work could have been done in a much smaller time frame, what is that based upon?
On the experience we have with construction and construction processes, and that's what we do here. We permit work, we inspect work, and we know how long a project takes under a normal circumstance. But as you said, this was a difficult year, and they had to make their adjustments with the structure, but also their just emotional adjustments to dealing with the changes to the structure. Understandably,
the year we've had, it would probably be impossible to say how much that would extend a project like this. I mean, it's a year later, and we're all still in here wearing masks, so clearly we're not back to normal. Certainly, the world has changed, and the time frames that you're used to working with are likely, they're going to be extended moving forward. That being said, do you recall on March 12th telling Mrs. Helms that you would look into moving this meeting out another 30 days?
No, I don't recall anything like that, but I knew that the meeting was already scheduled, and I don't have the authority to do that.
Understood. I do not believe I have any more questions for you.
Mr. Trask, any redirect?
Yeah, just a few questions. So what we're really talking about here is the kitchen improvements, the doors, and some improvements, some cabinet work in the bathroom. So yeah, you have an idea as to, if you were having kitchen cabinets installed in your home and a standard process, how many weeks would that take to put in the kitchen cabinets and the granite countertop? We saying something like 3-4 weeks?
That should suffice, yes. This is a pretty complex custom piece, but it should be able to be done within.
So if they can be installed in 4 to 6 weeks, they could be removed in 4 to 6 weeks, wouldn't you say?
Yes, with adequate planning and help, yes.
Okay. And we've been working on this project since September of last year at least, correct?
Correct.
So now we're 6 months into it. They could have removed it 5 times over since we started this work.
Possibly, yes.
Okay. Thank you. I don't have any other questions.
Ms. Milby, anything else based upon just that redirect?
Just briefly, and based on your experience, the timeline you gave, that would obviously be elongated or differ based on the company and based on the removal company or contractor, whoever it is that was hired. It would, of course, depend on their schedule and how far out they were scheduling as well, correct?
Sure.
So the timeline you provided, what is that based upon?
That would be based upon averages, based on a lot of construction experience and permitting experience.
But a more sought after, maybe this is subjective the way I'm saying it, but maybe a more sought after high-end entity that was going to be brought in it's not unfathomable to think that it may take 6 to 8 weeks to even get on their schedule.
That's not unfathomable.
Understood. Thank you. I have no further questions.
All right. Mr. Trask, any further witnesses?
No further witnesses.
All right. Ms. Milby, we've been going about 2.5 hours here. Does the city need to take a break? Or Ms. Milby, do you want to take a break, or do you want to keep going?
I have a 6 o'clock commission meeting.
Let's keep going.
No,
I was going to say,
Let's keep going.
have a
All right.
brief closing, and that's...
Okay, yeah, well, Ms. Milby, I was going to say, this is your part of the hearing. You want to call your clients as witnesses, you're welcome to. If you want to make a representation to me, show pictures or whatnot, proffer evidence, I don't, unless Mr. Trask objects to that, I don't necessarily have a problem with that. If you want to call any other witnesses, just let me know, or if you just want to make a legal and factual argument, that's fine too. This is your client's portion of the hearing.
Understood. And just for the sake of, I don't intend to call my client simply because my closing is going to be very succinct and to the point, and it's going to go back to that November 16th, 2020 letter. And there's A, B, C, D, item 2, and items on the next page there. And Ms. Portal already testified to the fact that this is what's remaining. This is what's going to get us in compliance. And I've showed you photographs here today that my clients are stripping their beautiful home of very, very, very high quality granite, doors. This is all set to be removed in the next week or two. That's on the books. Everything is in the process, and I can go through the remaining items, and I can tell you why they haven't been completed. That's just an example of some of the things that have been done. It is true, the granite in the kitchen has not yet been removed. It is very, very, very large, very, very, very heavy. That type of granite does not exist. So if it's cracked, there's nowhere else to get it. And again, it's massive. So yes, my clients, the reason they didn't remove that, it wasn't a willful disregard of instruction. It wasn't anything other than the fact that they were of the understanding that this was still an issue that Ms. Portal was going to address. Respectfully, I do think there's been a communication breakdown here. My clients have had to just show up on some days because they couldn't get return phone calls, they couldn't get return emails, and they are very actively trying to rectify this situation. Item 2, the porch, they have moved foundational poles back 30 feet from the seawall, and are in the process of looking into remedying that issue. That's everything. By the way, I'm only pointing out things in the letter that are that are still remain. Everything else has been completed or is on the schedule to be completed within the next week or two. Particularly the bathroom cabinet removals on the schedule, I believe, within the next couple of weeks. And I believe there was testimony earlier that French doors have not been removed. They absolutely have been removed. The fence, we've already touched on that. They can't get a permit yet. So again, they have to do, they've reached a blockade with that regard because everything else has to be done before they can get the fencing permit. And then the last items on that letter, the November 16th letter, let me make sure I'm got the right page here. My apologies.
Time.
Yeah, I understand.
Until we get the thumbs up, let's just take a 30-second break here. All right, Ms. Milby, whenever you want to move to your next point.
So let me just summarize in saying this. My clients are actively working on remedying these issues. They've been compliant. They've been very communicative. They're trying to get answers, and the delays are not only due to COVID, which is very understandable, as we've already touched on, but also what they feel is a lack of responsiveness from the city as in total. That being said, I've gone through the few things that remain. It's not a lot. They're actively, they're essentially gutting this home to comply. So here before you today, all we're asking is for an initial 90 days to comply. We also ask that you don't issue any sort of fine or sanctions because, again, this wasn't a willful disregard. This has just been a process that has simply taken longer than normal because, frankly, the last year has not been normal. Even the last 3 months, though we're all hopeful they haven't been normal. It's been construction. I know just personally, and the field I used to practice in, construction is, and insurance claims and anything involving homes right now, it's busier than ever. It's harder to get on people's schedules than it's ever been as far as hiring people to do this work for them. So all in all, again, actively working on remedying the issues, respectfully requesting an additional 90 days under the strange circumstances we found ourselves in, and again, respectfully ask that you don't issue any sort of fines or sanctions at this time.
All right, thank you, Ms. Milby. Anything else you want me to consider here today?
Not with respect to the relief sought, because again, we're just simply asking for more time.
Okay, and Ms. Milby, I think if what you're essentially telling me is your clients just need 90 days to comply with the November 16th letter.
November 16th letter, and the only thing I have to say about the November 16th letter is upon my communications with them, there was some ambiguity as to item 4. Now, that doesn't have to do with an actual building item, but it says that they have to pay some sort of fee, and again, they're just unsure what that is. So I guess it's 90 days, and if you a little asterisk saying pending responsiveness to their questions, because they feel like they've had a lot of questions left unanswered or left unanswered for extended periods of time.
All right, and I'll ask Mr. Trask about that in his before he does his closing, to try to give you and your client some clarity on number 4 as well.
Thank you.
All right, anything else you want me to consider before I open it up for public comment?
No.
All right. Thank you. All right, this is the portion of the hearing where we will invite public comment for case 2020.1258. Any members of the public that wish to speak in regard to this matter? All right, come on up, sir. What is your name?
My name's Chuck Dillon. I'm a resident of Madeira Beach.
You said Chuck?
Chuck, yes.
And last name?
Dillon, like Matt Dillon.
All right. Mr. Dillon, what is it you'd like to tell me about this particular violation?
Well, I'm just kind of listening as to what all's been going on, and I just want to make a few things understood as far as from a independent person looking at this. Seems as if the city has gone way above and beyond their efforts. Linda especially, for her to spend a weekend to do all that extra work to find out what is necessary for the people to get their house in compliance. The homeowners have hired a questionable builder, evidently, that there was a lot of miscommunication and stuff going on. From what I hear on that end, I don't know that there was a miscommunication going on in the city's standpoint. Also, just to be known, from what I understand, the building has to have many inspections before it's going to get its final occupancy permit. And there could be a lot of work that has to be done per the code enforcement about all the things that were not done or inspected since 2017. So they've got a long road ahead of them, the homeowners. So that's all I'm just wanting to know. Letting it be known, because as I'm sitting here, sometimes things go by the wayside. And
all right, Mr. Dillon, thank you for your comments. I appreciate that. Are there any other members of the public that want to provide comment in regard to case number 2020.1258? Seeing none, we'll go ahead and close public comment. Mr. Trask, you heard Ms. Milby ask a question about number 4, and so I'll open it up to you or Ms. Portal, or would you rather simply deal with that outside of the hearing and leave it just on the record? But if you could provide some information and clarification on that particular issue.
Number 4, meaning the difference in the building fee must be paid and additional administrative fees associated with services.
Yeah, it's minor. I think Ms. Milby was really asking about the additional administrative fees specifically relating to the FEMA review. Is that something you're going to ask me to order here today, or is that just a standard fee that the
Yeah, we're not asking you to enter in anything other than to get it in compliance, whatever it takes to get it into compliance, and the city will deal with the permitting fee and the administrative fee separately and apart. We're not asking for your direction on that.
All right.
But I would like to make a summary.
Yeah, please,
Okay.
go ahead, Mr. Trask.
Okay. So I don't think that there's any dispute based upon the testimony and evidence from all of these experts that you've heard from today, on these issues relative to the building being built without inspections, complete inspections. What we're very, very concerned about is that these people are violating the law. They're living in this home. There is no certificate of occupancy. We don't know how dangerous it is in that home because of the fact that there has been no final inspections on plumbing, electrical, HVAC. They shouldn't be there. And obviously, we'd have a different feeling as to compliance time frame if they weren't living there. But it being a life safety issue, that's how we see it. It should be a very short period of time. And we're suggesting that you find a violation of the cited code sections other than 94-83, which is in the letter I think that I'd mentioned early on that we're not pursuing that, because that's an administrative type thing. But the other code sections, we're asking you to find the violation in order that they come into compliance with all of these violations within 10 days or suffer a $250 a day fine. We don't think it's appropriate to allow them to live in this house another 90 days to remove a bunch of base cabinets in the kitchen or the bathroom, or take out the granite that they were given notice of 4.5 months ago. It's not appropriate to take a position, the Helm's taken this position, that they didn't know what they needed to do, or they didn't want to do it, or it's too expensive, or they're afraid they're going to damage something. When this home can affect the insurance rate of every home in the city of Madeira Beach because of the fact that they have not built this home FEMA compliant, it has to be figured into and reported. So we're very, very concerned about their, first of all, building this thing without having the appropriate building permits, going through the appropriate inspections, and ultimately dragging their feet since September of last year to bring it into compliance. I'd be happy to show you the pictures of them swimming in their pool that they presented at the city commission meeting a couple of months ago, and all the happy, smiling faces in their home as they live in it. But they would not be happy, smiling faces if, in fact, they get electrocuted because of the fact that something wasn't properly installed and inspected. So we're very concerned. We're asking that you find the violation, give them 10 days to bring it into compliance, or a $250 a day fine for every day thereafter.
All right, thank you, Mr. Trask. I'm going to go ahead and find there is a violation on 4 of the 5 violations. It sounds to me, based upon the testimony, that there was an incorrect value of the scope of work and that work was done, that they did not leave it open for inspections. That would be the first violation. The second violation is the evidence has shown that they did not submit the information necessary to issue the permit, especially for work done on the first floor. The third violation is they did not get approval from the floodplain manager prior to doing the work. And then the last violation is it's undisputed based upon the testimony I've heard, there's no fence around the pool. However, I understand the reason that they didn't get that permit is because the first violations are uncorrected. I'm not unsympathetic to the city's position that this work needs to get done, but it certainly appears that the owners are doing it. So I'm going to take a little bit of a blended position there. Instead of 10 days for compliance or 90 days for compliance, I'm going to give you 30 days for compliance. Ms. Milby, what I will say is we have these meetings usually every month. If we get to the point where we're 30 days from now and there's some issue you want to hear, I'll retain jurisdiction to entertain something, but I am going to go ahead because there are some life safety issues here involving the fact that there was work done that has not gotten a final inspection, and the fence not having a pool. There are some life safety issues there. So I'm not going to do it on a per violation basis, but if any of these violations exist after 30 days, then the city can come back and ask that we impose a lien on the property for those 250. So I'm going to do this in a two-step process, Mr. Trask. I'm going to do the findings of fact, conclusion of law, and order finding there's a violation. If after 30 days they have not brought the property in compliance, then I'd ask the city notice it, and I'll impose the lien, certify the lien at that point in time. All right? Okay. That concludes the hearing on case number 2020.1258. Is there any other business before me today?
No, sir, that's it. Thank you.
All right. Thank you all for coming. That concludes today's special magistrate hearing.